For the State of Ohio versus Adrienne Johnson. Ms. Johnson is before the court with her counsel, Mr. Gibbs. Ms. Nicholson, on behalf of the State of Ohio, we're here for sentencing. Has everyone had an opportunity to review the pre-sentence investigation?
Yes, Your Honor.
Ms. Nicholson, anything on behalf of the state?
Your Honor, the state did reduce these from a felony of the second degree. This is not Ms. Johnson's first time participating in the conveyance of drugs into a prison. The court is aware of the facts of this case from her co-defendant's trial. She facilitated the transport into the institution of 51 grams of methamphetamine. We did reduce it out of that mandatory time, but we would ask the court to impose a 24-month prison sentence. It's my understanding she has 6 days of jail time credit, and there is a $35 reimbursement to the Ohio State Highway Patrol.
All right, thank you. Anything from probation? Mr. Gibbs?
Yes, Your Honor. Well, the prosecution has certainly laid out, and this court is well aware of the facts and charges of this case. I would briefly ask the court to take a closer look at the picture of who the defendant is as a person at this point. Ms. Johnson is 37 years old. She's a local of Cincinnati and grew up in the Mount Healthy area with her parents, 3 sisters, and 1 brother. She used to be a cheerleader and track player. One of her memorable moments from that period of time was graduating early from high school on the honor roll and actually meeting President George W. Bush in 2006 and receiving the Presidential Awareness Award. I would like to take a moment to note that many of her family members, as she is well aware that she is being incarcerated today, she purposefully requested several of her family members not to attend just to have that be kind of a traumatic thing. That's certainly not a lack of love and connection, and I have received numerous correspondences from mother, godmother, and aunt and her son concerning that. I just want to note their absence. Her uncle and father are present. As of 2023, she and her children were actually living in a shelter. During that difficult time came through, and as of more recently, prior to this case, had obtained a townhome. She has a son, 2 sons. She helps care for her grandmother, who's 79 with bad kidneys and is a breast cancer survivor. She also helps her niece, Riley, who has severe mental delayment and mental processes. A regular theme that comes through family correspondence is that she's kind of the glue that holds the family together. Being a high school graduate, she has attended 3 semesters of college at the Jefferson Community College in Louisville, studying psychology. Unfortunately, she had to drop out due to a family living arrangement situation change where she was living with a relative which moved. She was planning to start school this August to become a peer advisor. Her current employment, which she just ended as of 3 weeks ago, was full-time as a cashier and runner in the general front house responsibilities at an Arby's. She also works part-time catering with Scott's Barbecue since 2018, showing a continued desire to provide for her family and be employed and be a productive member of society. She deals with a depression diagnosis. There was some significant trauma in her life. Heartbreakingly, in 2008, she gave birth to her daughter, who died in her arms suddenly and from a lung issue. Just 2 weeks ago, her 47-year-old cousin, with whom she was very close, passed away at the age of, again, 47 from a heart attack. And she also deals with severe PCOS, which requires medication to avoid excessive bleeding. She does attend worship at the Truth Temple with her father, and in our discussions, which we have had many leading up to this point, she does show sincere acknowledgement of this situation and significant regret. The greatest regret that she has repeatedly expressed to me is not being able to be there for her 2 boys, and she recognizes that that's her fault and that that's not, she's taking full responsibility of that. She would clearly state she's not the person she was 2 years ago when this all occurred. If I could briefly just state from a few of the letters from her grandmother, noting, she'd like to say that she's a person of genuine kindness, compassion, and character, and she's personally witnessed her true remorse. Her son, Demarius, states that his mother always encourages me, gives me advice, and reminds me to keep going. Everything she does comes from a place of love. I truly appreciate the sacrifices she has made to give me the opportunities and help succeed. And then finally, her grandmother states, I'm fully aware of her history, that this is the second time she's facing incarceration and seriousness. I do not take past or present mistakes lightly. However, I'm asking this because I've been firsthand witness to the remarkable, responsible, dedicated woman she's been over these last 9 years, working hard and resiliently for her family. And then finally, from her mother, I hope to provide insight into her character and the effort she's made to build a better life. Since her mistakes, my daughter's worked hard to change the direction of her life. She's secured steady employment, maintained that responsibility, demonstrating reliability and a strong work ethic. She's also established a stable home where she's raising her 2 teenage sons. Providing for them and being a positive presence in their life has been her highest priority. Appropriate sentence, we respectfully ask the court to consider the 9-month sentence, given all of these factors today.
Thank you, Mr. Gibbs. Ms. Johnson, is there anything you'd like to say?
I just want to say that I'm aware of my actions and I apologize, and I just pray that everything works out the correct way in the justice system today.
Ms. Johnson, I'm a little bit confused because you entered a plea of guilty, but yet in your statement you continue to say that you had no knowledge of taking the substance into the facility.
Yes, sir. I had to talk to my attorney because I was confused on how they was charging me with specific things like intent, and I was just confused because I didn't tell her, you know what I'm saying, to do.
No, but
things.
certainly the messages between you and Mr. Carney clearly established that you were involved and knew what was going on. Do you deny that?
If I could elaborate one thing, Your Honor, briefly, because we've had many discussions on this. As we went through the discovery and evaluated her case, obviously a large component of the prosecution's case against her is the testimony of the co-conspirator.
Well, I disagree with that. I sat through Mr. Carney's jury trial. I heard Ms. Carney testify at that trial. Mr. Carney came up here and he testified and gave some goofy story that didn't make any sense at all. But the messages between you and Mr. Carney clearly established that you knew what was going on and you were part of this. You were up to your neck in this. And the other part of that is the second time you've done it. I mean, you basically tried to explain this away as you were just giving a friend an old friend a ride to see her father in prison. She apparently tried to take a substance into the facility. Not apparently, she did. She took it in. I had no knowledge of her doing so. You gave her an old bag of
Flaming hot Cheetos.
Flaming Hot Cheetos that clearly was not Flaming Hot Cheetos because the bag was opened and it had something else in it. I mean, I'm just kind of confused. And then there was even, I believe there was a follow-up after she dropped it off in the prison. There was a follow-up call or text between Mr. Carney and her. Wasn't there something?
I know that Miss Carney confirmed that he had,
But that was after
the fact. But there were certainly.
So I'm going to give you an opportunity to try to explain those facts away.
No, like I said, he explained everything to me in detail, so I'm not denying anything. Like after that, me and my attorney have talked several times since the PSI, and he went into detail with everything. Like I said, the last attorney didn't explain a lot of stuff. It was some pages that I didn't get in it that he did give me. To show why the charges were filed. And like I said, today I take accountability, and that's all.
All right, anything else you want me to know?
No.
All right, the court's considered the statements made here today, the purposes and the principles of sentencing, the relevant seriousness and recidivism factors. Ms. Johnson, I have to tell you, we have a problem in our state, in our country, with people who are incarcerated getting illegal drugs. And this is the number one way that it happens, is that they're brought in from the outside by a family member or a friend through a visit. And it's got to stop. The other problem is that this isn't your first time. You've done this before. You've done this exact same thing before. So while you're having any communication with anyone in the Department of Corrections. I believe that ODRC has you red flagged, so you probably will never be permitted, but that's between you and them. The court does find that a prison is necessary to fulfill the purposes and principles of sentencing, including punishment, deterrence, and protection of the public. So on count one, the court's going to order you to serve 18 months in prison. On count two, the court's going to order you to serve 12 months in prison. And on count four, the court's going to order you to serve 12 months in prison, those to be served concurrent with each other. You have 6 days jail time credit. The court finds that you're indigent for the purpose of any fines, costs, or other financial sanctions. You're also subject to a discretionary period of post-release control, which means when you are released from prison, the adult parole authority may supervise you for up to 2 years. At this time, the court is going to revoke your bond and remand you into the custody of the Warren County Sheriff's Office for transport to the Department of Corrections. There is a deputy behind you. All right.
Fines and costs.
Indigent.
Thank you, Your Honor.
Yes, and yes, medication.
For the state of Ohio versus Adrienne Johnson. Ms. Johnson is before the court with her counsel, Mr. Gibbs. Ms. Nicholson, on behalf of the state of Ohio, we're here for sentencing. Has everyone had an opportunity to review the pre-sentence investigation?
Yes, Your Honor.
Ms. Nicholson, anything on behalf of the state?
Your Honor, the state did reduce these from a felony of the second degree. This is not Ms. Johnson's first time participating in the conveyance of drugs into a prison. The court is aware of the facts of this case from her co-defendant's trial. She facilitated the transport into the institution of 51 grams of methamphetamine. We did reduce it out of that mandatory time, but we would ask the court to impose a 24-month prison sentence. It's my understanding she has 6 days of jail time credit, and there is a $35 reimbursement to the Ohio State Highway Patrol.
All right, thank you. Anything from probation? Mr. Gibbs?
Yes, Your Honor. Well, the prosecution has certainly laid out, and this court is well aware of the facts and charges of this case. I would briefly ask the court to take a closer look at the picture of who the defendant is as a person at this point. Ms. Johnson is 37 years old. She's a local of Cincinnati and grew up in the Mount Healthy area with her parents, 3 sisters, and 1 brother. She used to be a cheerleader and track player. One of her memorable moments from that period of time was graduating early from high school with on the honor roll and actually meeting President George W. Bush in 2006 and receiving the Presidential Awareness Award. I would like to take a moment to note that many of her family members, as she is well aware that she is being incarcerated today, she purposefully requested several of her family members not to attend just to have that be kind of a traumatic thing. That's certainly not a lack of love and connection, and I have received numerous correspondences from mother, godmother, and aunt and her son concerning that. I just want to note their absence. Her uncle and father are present. As of 2023, she and her children were actually living in a shelter. During that difficult time came through, and as of more recently, prior to this case, had obtained a townhome. She has 2 sons. She helps care for her grandmother, who's 79 with bad kidneys and is a breast cancer survivor. She also helps her niece Riley, who has severe mental delayment and mental processes. A regular theme that comes through family correspondence is that she's kind of the glue that holds the family together. Being a high school graduate, she has attended 3 semesters of college at the Jefferson Community College in Louisville, studying psychology. Unfortunately, she had to drop out due to a family living arrangement situation change where she was living with a relative which moved. She was planning to start school this August to become a peer advisor. Her current employment, which she just ended as of 3 weeks ago, was full-time as a cashier and runner in the general front house responsibilities at an Arby's. She also works part-time catering with Scott's Barbecue since 2018, showing a continued desire to provide for her family and be employed and be a productive member of society. She deals with a depression diagnosis. There was some significant trauma in her life Heartbreakingly, in 2008, she gave birth to her daughter, who died in her arms suddenly and from a lung issue. Just 2 weeks ago, her 47-year-old cousin, with whom she was very close, passed away at the age of, again, 47 from a heart attack. And she also deals with severe PCOS, which requires medication to avoid excessive bleeding. She does attend worship at the Truth Temple with her father. And in our discussions, which we've had many leading up to this point, she does show sincere acknowledgement of this situation and significant regret. The greatest regret that she has repeatedly expressed to me is not being able to be there for her two boys. And she recognizes that that's her fault and that that's not, she's taking full responsibility.
The sentencing hearing in State of Ohio versus Adrienne, Johnson focused on a woman who had pleaded guilty in a prison drug conveyance case, but still faced serious skepticism from the judge because of both the facts of the offense and her criminal history. The hearing opened with the judge confirming that Johnson was present with her attorney, Mr. Gibbs, and that the prosecutor, Miss Nicholson, was appearing on behalf of the state. Everyone confirmed they had reviewed the presentence investigation. The prosecutor then laid out the state's position. She reminded the court that the original charges had been reduced from a second-degree felony and emphasized that this was not Johnson's first time participating in the conveyance of drugs into a prison. The court was already familiar with the underlying facts because the matter had been explored during the co-defendant's trial, and the prosecutor said Johnson had facilitated the transport of 51 grams of methamphetamine into the institution. Although the state had reduced the case and removed the mandatory prison exposure that would otherwise have applied, the prosecutor still asked the court to impose a 24-month prison sentence. She also noted that Johnson had 6 days of jail time credit and that there was a $35 reimbursement owed to the Ohio State Highway Patrol. That opening framed the case as one where the state had already extended leniency through the plea, but still viewed the offense as serious enough to require a substantial prison term, particularly because Johnson had done essentially the same thing before. Defense counsel responded by trying to widen the lens and show the court not just the offense, but the person standing before it. He acknowledged that the prosecution had accurately laid out the facts and charges, but asked the judge to look closely at who Adrienne Johnson was as a person at this point in her life. He described her as a 37-year-old woman from Cincinnati who grew up in the Mount Healthy area with her parents, 3 sisters, and 1 brother. He painted a picture of someone who, earlier in life, had promise and accomplishment. She had been a cheerleader and a track athlete, graduated early from high school on the honor roll, and in 2006 had even met President George W. Bush and received the Presidential Awareness Award. Counsel also explained that many family members were absent from court not because of indifference or a lack of support, but because Johnson knew she was likely going to prison and had intentionally asked several of them not to come so they would not have to experience the trauma of watching her be taken away. He said he had received numerous letters from her mother, godmother, aunt, and her son, all reflecting strong family support, and he noted that her uncle and father were present in the courtroom. He then described the hardships Johnson had been carrying. As recently as 2023, she and her children had been living in a shelter, but they had since managed to secure a townhome. Johnson had 2 sons, and also helped care for a 79-year-old grandmother who had kidney problems and was a breast cancer survivor. In addition, she helped with a niece named Riley who suffered from severe mental delays and related mental processing issues. According to the family letters, Johnson was often the glue that held the family together, a central figure people relied on for care, stability, and emotional support. Counsel continued building the mitigation case by highlighting Johnson's education, work history, personal struggles, and family role. He told the court that after high school, she attended 3 semesters at Jefferson Community College in Louisville, studying psychology, but had to drop out when a family living arrangement changed, and the relative she had been living with moved. Despite those setbacks, she had been planning to return to school in August to become a peer advisor. Her most recent employment, which had ended only 3 weeks before sentencing, was full-time work at Arby's as a cashier and runner handling general front-of-house responsibilities. She also had part-time catering work with Scott's Barbecue dating back to 2018, which counsel presented as proof that she had consistently tried to work, provide for her family, and remain productive. He also detailed the trauma and health issues that had shaped her life. In 2008, Johnson gave birth to a daughter who died suddenly in her arms from a lung issue, an event he described as heartbreaking and obviously life-altering. Just 2 weeks before sentencing, a 47-year-old cousin to whom she was very close had died suddenly of a heart attack. Johnson also suffered from severe PCOS, which required medication to prevent excessive bleeding, and she carried a depression diagnosis. Counsel said she attended worship at True Temple with her father and that in all of their discussions leading up to sentencing, she had shown genuine regret and sincere acknowledgement of the seriousness of the situation. The greatest regret she repeatedly expressed, he said, was not being there for her 2 boys, and she recognized that was entirely her own fault. He emphasized that Johnson did not claim to be blameless. Rather, she said she was not the same person she had been 2 years earlier when the offense occurred. To reinforce that picture, defense counsel read from some of the family letters. Her grandmother described Johnson as a person of genuine kindness, compassion, and character, and said she had personally witnessed her true remorse. One of Johnson's sons, Darius, wrote that his mother always encouraged him, gave him advice, and reminded him to keep going, and that everything she did came from a place of love. He said he appreciated the sacrifices she had made to give him opportunities and help him succeed. Her grandmother, while acknowledging Johnson's prior incarceration and the seriousness of the current case, told the court she had been a first-hand witness to the remarkable, responsible and dedicated woman Johnson had been over the last 9 years, working hard and resiliently for her family. Johnson's mother wrote that she hoped to provide insight into her daughter's character and the efforts she had made to build a better life. She said that since her past mistakes, Johnson had worked hard to change direction, secured steady employment, maintained responsibility, demonstrated reliability and a strong work ethic, and established a stable home where she was raising her 2 teenage sons. Her mother described providing for those boys and being a positive presence in their lives as Johnson's highest priority. Based on all of those factors, her role in the family, her work, her remorse, her children, her recent stability, and her difficult life circumstances, defense counsel urged the court to impose a 9-month sentence rather than the 24 months sought by the state. When Johnson herself was invited to speak, her statement was short but revealing. She told the court that she was aware of her actions, apologized, and prayed that everything would work out the correct way in the justice system that day. The judge, however, immediately confronted what he saw as a major problem in her presentation. Even though she had entered a guilty plea, her statement to the probation officer continued to claim that she had no knowledge of the substance being taken into the prison. The judge said he was confused by that contradiction. Johnson tried to explain that she had been confused about how she was being charged with certain elements like intent, and that she had not told her companion to do what was done. But the judge cut in and said that the text messages between Johnson and Mr. Carney clearly established that she knew what was going on and was involved. He asked whether she denied that. Defense counsel tried to step in and note that a large component of the state's case came from the testimony of a co-conspirator, but the judge disagreed sharply. He reminded counsel and Johnson that he had sat through Mr. Carney's jury trial, heard Miss Carney testify, and heard Mr. Carney himself take the stand and tell what the judge described as a goofy story that made no sense. In the judge's view, the key evidence was not simply the co-conspirator testimony. It was the messages between Johnson and Carney, which clearly showed that she knew what was happening and was part of it. The judge told her she was up to your neck in this, making clear that he saw her as deeply involved, not as some passive bystander. The judge then zeroed in on the facts Johnson had tried to minimize. He referred to the explanation she had apparently offered in the PSI, that she had merely been giving an old friend a ride to see her father in prison, and did not know the friend would try to take drugs inside. The judge flatly rejected that characterization. He said it was not a matter of apparently taking something into the facility. Johnson's companion did take the drugs in. He then focused on one of the concrete facts tying Johnson to the offense. She had given the woman a bag of flamin' hot Cheetos, but the judge pointed out that the bag was opened and clearly did not contain just Cheetos. He also recalled that there had been follow-up communication between Johnson and Mr. Carney after the drop-off, something he believed further undercut her attempt to portray herself as unaware. He essentially invited Johnson to try to explain those facts away if she could. At that point, Johnson changed her tone and acknowledged that after the PSI, her attorney had gone through everything with her in detail, including pages she had not seen before and the reasons the charges were filed. She said that after talking with counsel multiple times, she now understood the evidence and the case against her, and she told the judge that she was not denying anything and was taking accountability. When the judge asked whether there was anything else she wanted him to know, she said no. That exchange was important because it showed the court's concern that Johnson's remorse might be undercut by a lingering refusal to fully own what she had done. Even though she ended up saying she took accountability, the judge had already made clear that he did not believe her earlier attempt to distance herself from the scheme. With the allocution complete, the judge turned to sentencing and explained his reasoning in blunt terms. He said he had considered the statements made in court, the purposes and principles of sentencing, and the seriousness and recidivism factors. Then he stepped back and spoke more broadly about the problem that cases like Johnson's present. He said the state and the country have a serious problem with illegal drugs getting into prisons, and that the number one way it happens is through family, members or friends bringing them in from the outside during visits. In his view, it had to stop. He then returned to the fact that made Johnson's case especially aggravating. This was not her first time. She had done this exact thing before. That fact, more than anything, seemed to drive the court's conclusion that prison was necessary. The judge questioned why she was having any communication with people in the Department of Corrections at all given her history, and said he believed the Ohio Department of Rehabilitation and Correction had probably red-flagged her, meaning she might never be permitted to visit again, though he acknowledged that was up to prison authorities, not him. Still, the point was clear. The court viewed Johnson not as someone who made one terrible mistake, but as someone who had already been through the system for prison drug conduct and nevertheless became involved in another nearly identical scheme. That prior history destroyed much of the defense argument that this was an isolated lapse by an otherwise responsible caregiver and employee. To the judge, the pattern showed a willingness to participate in a dangerous and highly disruptive practice that fuels drug use and instability inside correctional institutions. After laying out those concerns, the judge formally found that prison was necessary to fulfill the purposes and principles of sentencing, specifically punishment, deterrence, and protection of the public. He then imposed sentence count by count. On count 1, he ordered Johnson to serve 18 months in prison. On count 2, he imposed 12 months. On count 4, he imposed another 12 months. All of those terms were ordered to run concurrently, meaning her total prison sentence would be 18 months, rather than stacked consecutive terms. The judge awarded her 6 days of jail time credit. He also found her indigent for purposes of fines, court costs, and other financial sanctions, meaning the court was not imposing monetary obligations beyond what had already been noted. He advised Johnson that she would be subject to a discretionary period of post-release control after prison, under which the adult parole authority could supervise her for up to 2 years following release. With sentence pronounced, the judge revoked her bond and remanded her immediately into the custody of the Warren County Sheriff's Office for transport to the Department of Corrections, noting that there was a deputy standing behind her. The clerk or counsel then referenced fines, costs, indigency, and medication, and the judge appeared to acknowledge the issue of medication as the hearing came to a close. In the end, the hearing showed a sharp divide between the defense's portrait of Adrienne Johnson and the court's view of the case. The defense presented her as a 37-year-old mother, caregiver, worker, and woman who had survived significant trauma, helped hold her family together, supported children and elderly relatives, and genuinely regretted the consequences of her actions, especially the time she would lose with her sons. Her lawyer emphasized her education, employment, faith, health struggles, and the emotional support reflected in the family letters, asking the court to focus on the person she had become rather than only on the crime. But the judge could not get past two things. First, that the evidence clearly showed she knowingly participated in the delivery of methamphetamine into a prison despite her attempts to distance herself from the details. And second, that this was not her first prison conveyance case. The court saw the offense not as a technical drug case or a misunderstanding about intent, but as participation in one of the most damaging ways contraband enters correctional institutions. By the time sentencing was imposed, the judge had effectively concluded that Johnson's family support, employment, and expressions of remorse were real but not enough to overcome the seriousness of the conduct and the repeat nature of it. The final result was a concurrent prison sentence totaling 18 months, 6 days of jail credit, possible post-release supervision for up to 2 years, and immediate remand into custody. An outcome that reflected the court's belief that punishment, deterrence, and protecting the system from repeat prison drug smuggling outweighed the defense plea for leniency.